Jennifer Anderton is suing her former friend, James Sorensen, for personal training and a fraudulent investment.
Court come to order. All rise.
Have a seat, please.
Case 2125, Anderton versus Sorensen.
Thank you.
You're welcome.
Ms. Anderton, your case against the defendant is twofold. First, you claim a loan to him in the amount of $10,000. And while he doesn't deny that you gave him $10,000, it is his defense that this was not a loan, but an investment in a project that went south. It went south because somebody conned him, and thus you were conned as well. Somebody took off with the money. The second part of your lawsuit is that Mr. Sorensen is a trainer of some sort, a personal trainer, fitness trainer, and you retained him to put you on some sort of a regimen of both diet and exercise. And you paid him in advance. He wasn't forthcoming with all of the training sessions he was supposed to give you, became unavailable. You want a refund of some of that money. So the first thing I'm going to deal with in your lawsuit is the $10,000 exchange of money. If I find that that, in fact, was a loan or was fraudulently entered into as a result of being duped and being a dope, then I'm going to give you back the money. Then I don't have to get to the training because that's the limit of my jurisdiction. Do you understand?
I understand.
Okay, great. How did you meet him?
I met him on a dating site, actually.
When?
Early June 2021.
Did you date?
We befriended each other. And after our first meeting, that is when I had just come off of a ventilator of 10 days. I was a nurse, contracted COVID. He actually came to my home and said, I could really help you get back to where you were. I needed rehab.
Okay, so after the first meeting, you were not dating?
No.
Is that right, sir?
That's correct.
And that was in June of 2021?
Yes.
When did you, Mr. Sorensen, tell Ms. Anderton about this investment opportunity?
It was about a month into...
So 4 weeks later?
Right.
4 weeks later, you became close enough to discuss with her a business opportunity?
Yes.
And did you discuss this business opportunity with her in her home or over the phone?
In her home.
So I want you to tell me your version of exactly what you told her.
So I had a friend come to me and...
You had a friend whose name is?
His name's Scott.
Scott what?
I can't remember his last name.
I don't believe you.
Okay.
If it's true, then it didn't happen. If it's true that you can't remember his last name, it's because he doesn't exist.
Oh, he does exist.
Oh, sir, you didn't give all that money to somebody whose last name you don't know. I want you to understand that. Then you're looking at me and saying I must have stupid written on my forehead. You don't look like a stupid man.
Absolutely not.
Yeah, you look like you could be a cunning man, but you don't look like a stupid man. So if Scott doesn't have a last name, he didn't exist. I want you to tell me that's in my brain. In my brain is if you can't come up with a first and last name of somebody that you gave thousands of dollars to, he didn't exist.
Okay, in your mind.
Keep going.
I'm not going to keep going and dig any holes. I'm just telling you what the facts are.
No, those aren't facts, sir. That's a fantasy. You know, you're not mentally challenged in any way, are you?
No.
I want to tell you, if I told my 9-year-old grandchild who asked me for $100 because she wanted to invest it with a friend, I would say, what's the friend's name? I don't know. See, I'm not giving you $100 to invest with somebody whose name you don't know. Because I'm absolutely positive that if you said that to her, she would have said, well, what's this person's name? I want you to tell me now, Mr. Sorensen, what was the investment?
It was for Happy Pills.
It was for what?
Happy Pills?
Don't look at me.
Happy? Did you say Happy Pills?
Yes.
Okay. Tell me about it. Tell me what you told her. You want to invest in Happy Pills.
Yes.
What she'd say to you? She'd say to you, I'm a nurse, you know, so I'm an educated person. What's wrong with you? Okay, keep going. Keep going. I want to invest in Happy Pills.
Right.
Your friend Scott.
It was a friend of a friend. His name was Scott, okay? And he introduced me to him and said that, hey, he went...
No, you mean Scott introduced you to somebody else?
No, my friend introduced me to Scott. I didn't know his last name, but we knew that he was in the industry.
Okay, so your friend introduced you to Scott?
Yes.
What's your friend's name?
His name is John. I promise.
Where does he live?
He lives in Salt Lake.
What's his telephone number?
I have no idea what his telephone number is.
Just a second, get out your phone and tell me what your friend's telephone number is. Everybody has their friend's number in their phone.
I don't know what his telephone number is.
Then you see why I don't believe you, sir? Do you understand why I'm having a problem with your story?
It's okay.
Do you understand why I'm having? So a friend whose number you don't have in your phone wanted to introduce you to somebody whose name you don't know to invest in happy pills. And this is what you told her? No, I'm asking you a question. Is this what you told her? I have a friend.
This is what I told her.
John, I have a friend, John, who knows a guy, Scott, who has this company that's going to make happy pills. I just want to know if that's what you're trying to tell me that you told this woman.
I am. It's okay. I don't know why she would make up that story that
No. She's not making up the story. You're making up the story.
Okay.
And if I'm wrong about this, I actually don't feel badly, sir, because then you're the dope that got duped.
And later today,
You devalued her car while you had it.
Yeah, okay.
You used the car for 2.5 years that was running. It stopped running because the engine was blown.
Yes.
And then you stopped making the payments on it.
Yes.
Yeah.
Jennifer Anderton claims her former friend, James Sorensen, owes her for a fake $10,000 investment.
Okay, keep going.
You know what happy pills are?
I assume that they make you happy.
Right. Yeah, they are. It's Molly.
I assume that they make you happy.
Okay.
Right?
Yeah. And so he went around to festivals and he sold Molly there.
He sold what?
Molly.
Molly's.
MDMA. It's an illegal drug.
Oh, okay. So you told her you wanted her to make an investment with you with a big return on your money.
We talked about this for a long time.
Who did?
Me and...
You couldn't have talked about it for a long time, sir. You only knew her 4 weeks.
Okay.
You only knew her 4 weeks. Tell me about this $10,000. Did you take it out of a savings account? Do you have that from the bank?
Yeah, right
I'd
here.
like to take a look at it. You want to tell me, Miss Anderton, the circumstances surrounding you transferring $10,000 to him?
He approached me saying that he needed a hard money loan for his business. He had an e-commerce business with supplements. His father and mother had given him the loans in the past, for the past 5 years, and they've gotten a good return. It was a for sure deal. He goes around and this is their festival project time. They make a lot of money doing this.
What does he do?
For supplements. Like,
So he sells supplements?
Yes.
And it was his business? Mm-hmm. That's
Yes.
yes. Did he ever mention a guy, Scott, to you?
No.
It was his business.
Yes.
And he said that his parents had helped him out in the past, had invested with him in the past. So now I understand a little bit better. I see the withdrawal for $10,000. So tell me why he needed a hard money loan.
To buy the product to take to these festivals and
Sell him.
sell them, yes.
Okay.
So he needed it for product.
And when did he tell you that he was going to return this money?
Within a week or two. That it was a week or two of festivals. This was the busy season. He does this every year, and this is a for sure return. And if I did this much amount of money, $5,000, this is how much I'd get back. If I did $10,000, it would be a $15,000 return for me. And I'm like, wow, I could pay off my student loans. I could, yes, do a lot with that.
Okay, so to synthesize what you told me, he told you that this was an investment in his company.
A loan.
A loan for his company for products so that he could go out, sell them for the next several weeks,
Correct.
and you would get a return of 15% on your money.
50%. So a 10.
50? 50? Sounds too good to be true.
Yeah.
Has nothing to do with the company.
The Venmo transfer of $2,000 was to him in June,
June 16th of 21.
and a withdrawal of $8,000.
Same day.
Okay, now, where did you put that money, sir?
I gave it to Scott.
Okay. Okay. I want to tell you, Mr. Sorensen, you have parents who gave you money?
They have in the
Just a
past,
second.
not as you
just
would
say you
say.
have parents
Not in,
that gave you money.
they did not ever give me money for my business ever.
What did they give you money for?
Christmas? They never gave,
Oh, I'm
they
not
never
talking-
financed for me for anything in my life. Nothing.
Oh, then you
I don't
lied
know
about
why. I don't know why she would make up that story that my parents gave me.
No. She's not making up the story. You're making up the story.
Okay.
And if I'm wrong about this, I actually don't feel badly, sir, because then you're the dope that got duped.
Oh, absolutely. I know.
Then,
I'm a dope
just a
that got
second,
duped.
that if you gave
not.
money to John, to Scott, then you're the dope that got duped because they were your friends. That's all I have to tell you.
I understand.
That's all. Judgment for the plaintiff in the amount of $10,000. We're finished. Thank you.
This court is adjourned.
I think it was fair.
I think that was a fair judgment.
We both understood what we're getting into.
No, not until after like 3 or 4 months, and I think he brought that up in fear of me going to the police.
Time to part ways, and definitely learning curves on both ends.
Don't do silly things. It was definitely a learning curve.
I'm glad that things happened the way they did.
Something I'll never do again. And be a little more careful with your money and your investments, and don't trust everybody. I'm too trusting.
I just find it very funny that his entire business venture, was selling illegal drugs at festivals. That was the only plan. That was the whole venture. There was no...
That's really what he said?
Whether it was Scott, whether it was John, whether it was
But that
Joe.
was the business plan. That's Happy Pills. Thank you, by the way, for explaining what that was to me.
I didn't understand at first either, but when he said Molly at festivals, it's like, I'm pretty sure that's illegal. I'm pretty sure that's not a business.
Right.
So I'm glad she got her money back.
Me too. Me too. It was ridiculous.
There was a couple dopes getting duped in that situation.
You're absolutely right.
Case 2107, Breland versus Chenal. All parties, please step forward.
Kashana and Michael Breland are suing Kashana's stepdad, Harry Schnall, for car repairs and damage credit.
Miss Breland, this is your stepfather.
Yes.
That's your dad.
Yes.
This is your claim. He needed a car because his car, which was an old Cadillac, was going in for repair. Your dad had bought you a car in 2018.
Yes.
And when he bought you this car in 2018, it was a 2013 car that you kept 18, 19, and 20?
The vehicle? No, I had the vehicle from 2018 to July 2019.
So just for 1 year?
Yep, July in 2019 was when I made the agreement to give the vehicle to...
Okay. You made the agreement to give it to your stepfather with a proviso because you were buying a new car, another car.
Yes.
According to you, that he would take over the payments on the car because there was a loan on the car that you were paying off and that your father was a signatory on.
Yes.
And you have children, and I don't know why this car was no good for you anymore, but you said you got another car because of your children.
Yes, I got another vehicle because I had an additional son and it just wasn't enough room for 3 kids.
What kind of car is it?
It was a GMC Terrain. It's an SUV 5-passenger, but I felt like I needed a little bit more room, so I ended up getting a 7-passenger. That way I could have the 3rd row.
Okay. So according to you, the arrangement was he would take over the payments on the car, and the car would be turned over to him as soon as he finished making the payments on the car.
Yes.
Was that your agreement with him?
Yes, that was our agreement.
And he did make payments on the car in 2019, 2020, 2021, and according to you, he stopped making payments in 2022. What month in 2022?
January 2022 was the last payment I received.
As a result of which, both of your credits were at risk. He dropped the car off at some relative's house because the engine was blown. He had it towed to some relative's house and stopped making the payments.
Yes, that is correct.
Your stepfather says, well, that really wasn't the agreement. My Cadillac wasn't working. It was in the shop in 2019. And the agreement was, while the car was in the shop, I would use your car and pay you $225 a month for it. But as soon as my car was out of the shop, you would take the car back. That's what you say, sir.
Yes. Yeah, I would take it back until my car got fixed. And the only reason it took so long to get fixed because of the pandemic, And
why? People couldn't go into their garage to fix a car?
Yes, they probably could, but at that time, I really didn't have the money to go and pay for it, so I just...
Well, that's your problem.
I understand that.
Well, that's your problem. So the car was fixed, but you didn't have the money to go and pick up the car.
No, it wasn't fixed.
Oh.
So I didn't have them fixed until I'd be able to get the money to go have it fixed.
Did you explain that to her, sir, when she gave you the car?
No. See, my agreement thought I was going to keep the car until my car gets fixed and I would make the monthly payment. That's what I had.
I understand that, but what... Yeah. I understand that.
Okay.
Mr. Chenal.
Yes.
But taking your story, if my stepfather said to me, listen, I'll take your car, I have a car that's in the shop, I'll use it and pay for it while the car's being fixed.
Not what?
In my view, that would be, well, maybe it would take you 2 weeks. Maybe it would take you a month. Maybe it would take you 2 months, but it wouldn't take you 3 years.
Your Honor, what I'm saying, my car wasn't in the shop, my car was broke down. And I told her, I thought we had agreement to me make the payment on that car till I get ready to get
You
my
told me that already.
car fixed. But I didn't put it in the shop till I was able to put it in the shop to get fixed.
You devalued her car while you had it.
Yeah, okay.
You devalued the car. You got a car that was running. You used the car for 2.5 years that was running. It stopped running because the engine was blown.
Yes.
So it was dead stop. You had to have it towed to somebody's house.
Yes.
And then you stopped making the payments on it.
Yes.
Yeah.
Yeah. I hear what you're saying.
Right.
I think she had a lemon because...
She didn't have a lemon. You drove it for 2 years.
Yes, but I just had got the oil changed in that car a month before the engine blew.
And you drove it for 2 years.
Yes.
Well, then it wasn't a lemon.
Kashana and Michael Breland claim Kashana's stepdad, Harry Schnall, owes for car repairs and damage credits.
Now, you have to act not only responsibly, but it would seem to me morally. This is your stepdaughter. You've known her for a long time.
Yes.
She went out, based upon her agreement with you, she went out and bought another car.
Yes.
Does the other car have a loan?
Yes.
Well, now she's stuck with 2 loans, and one of them has a car that you blew the engine on.
I made sure the main was up on that car. I think she had a lemon because...
She didn't have a lemon. You drove it for 2 years.
Yes, but I kept... Well, I just had got the oil changed in that car a month before the engine blew. I don't know why the engine blew.
How many years did you have the car?
2 years.
And you drove it for 2 years.
Yes.
Well, then it wasn't a lemon.
Okay.
How much was left on the loan of the car?
There is still $3,752.63 owed left on the vehicle.
Okay, and where is the car now?
It is parked at a relative's house.
Your problem is the car is in your name. So you have to sell the car, subject to this lien. You have to be able to get something for the car. Do you understand?
Yes.
What's the value of that car?
Based on 80,000 miles, it didn't say in the papers, but around 7,000 to 9,000.
And what if it's in very poor condition?
I have to look into it.
Take a look and see, because this car so far is not running.
Yeah.
And it hasn't been running for almost now a year.
Yes, that's correct.
So at best, you can sell it for scrap. So you have to get the car and you can scrap it because nobody's going to buy it when they can't drive it.
So Kelley Blue Book will not provide an estimate for poor conditions, vehicles that are not running or in poor condition. But for a fair condition, they say between 5,000 and 6,000.
Well, this is non-running.
I know.
It's been
So
not running for a year.
I can't get an estimate for a non-running vehicle from Kelley Blue Book.
So now I know what the parameters are. You want to tell me about where this agreement took place with your stepfather?
The agreement took place at the car lots because I was in the middle of getting a new vehicle, so we were at the car lot.
So that was in 2019?
July 3rd, 2019.
So you went with him to get the new car?
Yes.
Oh, good. So tell me about the conversation.
So I asked him, I was like, hey, do you think that, because in order for me to get this new vehicle, they said that I had a debt to income ratio thing because I couldn't get a new vehicle with owing money on the other vehicle. So I said, hey, how does this sound? You're down a vehicle because the engine blew on your prior vehicle. How about I give you this car, you finish making the payments on it, and then I get my new vehicle. But in order for me to get my new vehicle, I needed a co-signer. So I said, how about this? How about you co-sign on this new vehicle for me? Yes, my stepfather. You co-sign on this new vehicle for me. I'll make the payments like I always do. And you just take over the payments on my GMC Terrain. He said, okay, yep, we can do that because I need another vehicle.
So he is the co-signatory on your new car?
That at the time, that was the vehicle that I had. I now have a different vehicle.
You mean in 2019 you had yet another car?
Yes. But I made sure that I paid it off and there was no effect to him by any means.
Okay.
Because I knew that, it wasn't just in my name, it was in his name also. So I didn't want to do that to him. So I made sure that not only did I pay the vehicle off, but I got the transmission repaired and then I sold it.
So what does your father have to do with this case?
So my father was affected because with the payments being late.
The car was in my name also.
Oh, so it was in joint
Yes, on the
names, you and your
title.
daughter.
Well, they were supposed to put it as me, the co-signer, but they put me as
The primary.
Exactly.
Yes.
Okay, all right. Have you been making the payments since January?
I was making payments on it from February to September.
And then what happened?
I couldn't afford to make the payments anymore. I'm a single mom of four kids.
So what happened?
So it's behind now.
Since September?
Yep, it's behind since.
September, October, November. So it's behind 3 months.
Yes.
Have they notified you that they want to repossess it?
No,
they haven't
not
notified.
repo. They've given us options to try to save our credit after
Okay, I'd like to see what those options are. Did they send it to you in writing?
No,
Did they send
no,
you
it
a
was
letter?
verbal on the phone when they called, and we were discussing other options that they may offer to
Okay, so
make
what was the
this so
best
it's not
option
worse.
that they offered you?
The best option that they offered was basically to come up with about $396 to pay to get the car note caught up because it was 4 months behind. The car note's $225 each month. So it wouldn't have got...
No. So they didn't offer you a whole payout. They just offered you
to catch up.
to catch up.
Yeah.
Right.
Okay. But still, what's due and owing on the car is $3,752.
Yes.
Okay. And when your stepfather agreed to that, did he say anything to you with regard to his Cadillac going in for service and he was going to just use it until his Cadillac got...
No, Your Honor, that is incorrect.
Okay. You remember going with your stepdaughter when she was purchasing a new car in 2019?
Yes, I do.
Did you co-sign that car for her?
Yes.
So far what she says is accurate.
Yes.
And at that time, did you take her old car?
Yes.
I have no idea what you can get for this car. And you know how you relied on him to be a good guy and to do what he was supposed to do?
Yes.
I'm awarding you $3,752. That's for you to pay off the bank. Then I don't think you can find a buyer for this car. You may have to scrap it, right?
Yes.
It's possible that there's no point in fixing it. You're not going to invest thousands of dollars in fixing it when it probably is at best worth $5,000. And if it's going to cost you $3,000 to try to get it up and running, it doesn't pay.
11,000.
It doesn't pay. So I'm going to rely on you to do the right thing. It sounds as if you do that while I'm awarding you $3,752, whatever money you get for the car goes to him. Do you understand? If you scrap it for $70, he gets it. I don't see that it's worth much more. I certainly wouldn't invest in a car that's been sitting dead for a year with a blown engine. Judgment for the plaintiff in the amount of $3,752. We're finished.
This court is adjourned.
I think it was pretty fair.
I think it was very fair.
My agreement, though, I pay for the car until I get my car fixed.
I've tried multiple times to reach out to him, and I couldn't get a hold of him, so it's really sad that it had to come to this.
You had to do what you had to do. That's all I can say.
I've learned that you can't help anyone, not even family.
Time to move on. Go on about my business, yes.
I'm a nice person, so I guess you just sometimes can't be nice to everyone.
You know what's so disappointing? She seems like a very lovely young lady. Her father seems like a nice man. He had actually helped to purchase the first car, and I think co-signed a loan for her or bought her the car in 2018 that she then turned over to him. But he's been her stepfather for a long time. How could you be so irresponsible?
And you know she's a single parent of 4 children who relies a lot on her credit.
And her credit on her car.
And a car.
And she's maintained her credit.
Yes, except for the fact that her stepfather sort of ruined it for her a little.
He really didn't have a defense.
No.
I don't think he had a defense. I don't think that you borrow somebody's car until your car is fixed 3 years later. I don't think that's...
Terry Smith is suing her ex-husband, Tony Smith, for 3 ATVs and a lawnmower.
Court cut in order. All rise.
Have a seat, please.
Hello, Judge. Case number 2148, Smith versus Smith.
Thank you.
You're welcome.
Ms. Smith, this used to be your husband. You haven't been married in a long time, but after your divorce, you sort of remained friendly and you had some business transactions together. What kind of business?
I would refer real estate business to him and refer flipping homes and the construction work.
Did you take part in that as well?
I did.
In what year were you divorced?
2015.
So this briefly is what I gather from the complaint and the answer in the counterclaim. At some point, according to you, you purchased 3 ATVs. Those 3 ATVs were originally supposed to be used in business.
We purchased more than 3.
How many did you purchase?
Those were the 3 that were left. It was 14 of them that we had.
And when you purchased those together as part of a business?
No, those were mine. I purchased it. The business
14.
business was mine. Yes.
14?
Yes.
You purchased them, you paid for them?
Yes, I did.
Okay, and you can prove that to me?
I can.
Okay. Do you agree with the fact your former wife purchased the 14 ATVs?
Yes, I agree, but it was underneath an LLC that was formed.
I don't care whether it was under an LLC or a little umbrella or a big shoe. She bought the ATVs.
Yes.
So one of the things that's in question is the ATVs now are in your custody?
The remaining ones are in my home, yes.
3.
Yes, ma'am.
And you want them back?
I do.
She bought them. Why doesn't she get them back?
Because, Your Honor, there is an outstanding invoice for work that I have done for her.
What?
It's construction work and other odds and ends that was helping her.
That's not part of your counterclaim as a set-off, sir. That's not what you say at all.
Okay, and also there is a counterclaim.
You have a counterclaim. That has to do with your truck. So there really is no reason that you are holding those ATVs. Are they new?
No, they were demonstrator models. There's 1 new one and 2 demonstrators.
Okay, so within 5 days, you make arrangements to get those, okay? I assume that you have children together?
No.
So I assume that you are two civilized people. I don't know whether you need a police officer to accompany you to get those, but within 5 days, make arrangements to pick them up from his house. They're yours.
I will. Thank you.
Are we then finished with your claim?
Now, there's a lawnmower, an electric zero-turn lawnmower.
Okay.
It's also part of that claim.
Okay, I sort of remember that. Is that an old lawnmower?
No, it was purchased in May of 2021.
And who was it purchased for?
He asked me, since he could not get it on credit, if I would buy it for him, and the next real estate transaction that I referred him, he said when he got paid, he would pay me the $4,800 back.
Okay.
And so when I asked for it, he said he had put it in a separate savings account to save it for me. And I said, well, I don't need you to save me my money.
Got it. So you have the lawnmower?
Yes, ma'am.
You picked that up with the ATVs.
Thank you.
Got it?
Thank you.
Perfect. Now we have to come to your counterclaim. Your counterclaim is sort of interesting and can be, I think, probably equally swiftly disposed of. After your divorce, you needed a truck. You didn't have any money or credit, according to what I've read, and you purchased a truck in your name for him. And the agreement was that you would make the payments on the truck because you couldn't get credit. Is that right?
Yes, ma'am.
The truck was purchased in what month and year?
August of 2020.
How much did the truck cost?
$58,000, somewhere in there.
And how much of a down payment did you put down?
$500.
Is that right?
Yes,
That's good. You must have had good credit.
I do.
Good. And what were the monthly payments, sir?
900 and I can't remember exactly. It was under 1,000. It was 940 something dollars, I think.
And you paid for the truck the month of August of 2020 and all through 2021. Until when? When was your last payment on the truck that you made, that you can prove to me that you made?
I have all the payments.
Just tell me, when was the last payment you made on the truck?
It was August of this year.
August of 2022.
Yes, ma'am.
And that's what your bank records will indicate, that you made a payment of $900 and some odd, August of 2022. And in what month did your former wife repossess the truck, which was in her name?
It was September 20th.
Now you're going to tell me why you repossessed the truck. Let's talk about the violations. Driving without tags, only 2 months. When we forget or we're traveling and we don't get registrations for our cars, we don't drive those cars. Because if you're driving with expired tags, that's against the law.
Terry Smith claims her ex-husband, Tony Smith, owes for 3 ATVs and a lawnmower. Tony is countersuing for the value of a truck.
Okay, you made a payment of $900 and some odd,
Yes, ma'am.
August of 2022. And in what month did your former wife repossess the truck, which was in her name?
It was September 20th.
Okay. Now you're going to tell me why you repossessed the truck.
Yes, that truck's first payment was due on October 30th of 2020. I made the payment on November 28th.
No, I'm not interested in history.
Okay.
I'm interested in, he says that he was making payments on the truck. You say he stopped making payments on the truck, which is why you repossessed it. You didn't want your credit to be at risk.
It was 2 of the first payments that I made, and I said, I'm not doing this again like I did on the last truck where I make every payment. But the insurance, I asked for the insurance to be paid since April of 2020, and I requested this on June the 28th of 2022, and I said, here's the insurance premiums I've paid on the GMC truck since we've had it, and it was $1,596. His reply was, I'm happy to pay the insurance on my truck, but don't just dump 2.5 years on me at a time. I will need to break this up into 3 increments. This was June. I don't have any money. The insurance and taxes, the taxes this year is the first time he's ever paid taxes on the vehicle, and it was 1 year late. He drove on an expired tag for a total year. The reason
is that just a second, is that correct?
I'm sorry?
Did you drive on an expired tag for a year?
No, ma'am, it was only a few months late.
So you drove
It wasn't an entire year.
How many months?
2 months.
Oh, that's too long.
I agree.
And was your agreement that you would maintain the insurance for the truck as well?
That was something that we discussed, and because of the real reason she actually agreed to purchase the truck, we had a previous truck that was also I was driving, and because of the LLC that the truck was under, it was a very high commercial insurance rate. So she felt that it would benefit her to get another truck and come out from under the commercial rate that she was paying for insurance, and she was going to put it in a group insurance policy.
Where is the truck? Where is the truck? You've had possession of the truck.
That's correct.
So you get all the benefit of the truck, and she gets all the detriment.
I'm just referring to what we
I'm
discussed.
just what I'm not getting from you, sir, is any sense of the whole idea was this is going to be my truck. As soon as I finish making all the payments on the truck is going to be mine, right?
That's correct.
And if you didn't make payments on the truck, absolutely, she has a right to repossess it if that was your agreement, and you acknowledge that that's your agreement, right?
That is the agreement, but I have made every payment, and I have paid all the taxes.
Well, the word paid all the taxes eventually, didn't pay them when due.
That happened once.
Didn't pay them when due, pay them eventually. What about the insurance?
The insurance, I agreed to catch up and pay her back for once she told me what it was.
Okay.
I never received any information about the insurance amount until she sent it all in one.
Okay, she sent it to you in one email. That was in June, and you said I couldn't pay it, and she repossessed the car in September. Between June and September, did you make any insurance payment?
No, I did not.
Why?
It was a lot of things going on at that time that there was money owed to me as well from her. So it was a lot of discussion going back and forth about that.
Well, but one thing is clean. You know about the insurance, and if there's money that she owes you from construction or real estate or whatever it is, you have to put that in compartments. Where is the truck now?
I took the truck back and it is sold.
Did you ever tell him?
He wouldn't talk to me. He hasn't talked to me since May.
So you had the truck for approximately 2 years?
Yes, ma'am.
And how much in total did you pay for the truck?
The exact amount added up was $18,736.
So you paid approximately $9,000 a year, right?
Correct.
Your Honor, we had an agreement of $1,200 a month on the truck to cover the insurance and taxes up front before it was purchased.
That's not true.
Well, if you paid approximately $9,000, Mr. Smith, and you used it for business, correct? That's what you used the truck for. So you paid approximately $750 a month if you paid $9,000 each year for the 2 years, $1,870. You say the payments were $900 a month. That means that there was a shortfall.
Can I bring us? It was more than 2 years. It was August of 2020 until
September.
August of this year.
Well, that's 2 years.
There's also a down payment
of $500. I'm not.
Okay.
So that's $750, sir. I always have a problem with people who are no longer married and no longer happy with each other, where one party has the obligation and has all the liability on a vehicle, including their credit and their insurance, when the other person is being either irresponsible or blinking at certain violations. Let's talk about the violations. Driving without tags, only 2 months. When we forget or we're traveling and we don't get registrations for our cars, we don't drive those cars. Because if you're driving with expired tags, that's against the law.
I would like to point out, if I may, that the bill for that obviously went to her address. It was not given to me. Now, that's not my. I understand that I need to be aware of it, but I never received that bill.
I gave it to him the very month it came in.
Just a second.
That's not true.
Just a second. You're a big boy. You know when your car has to be registered, you have a little yellow tag on the back like everybody else. And insurance, you know, you're supposed to pay insurance. That was your agreement. You were supposed to pay insurance. And you didn't pay insurance. She's going to show me how much was left on the loan and how much she sold the truck for. If she sold the truck for more than was left on the loan, the difference between, you're looking at me, the difference between that belongs to you.
Terry Smith is accusing ex-husband Tony Smith of wrongfully keeping 3 ATVs and a lawnmower. Tony claims Terry owes him for the cost of a truck.
Okay, well, are you working now, sir?
Yes, ma'am.
Great. She sold the truck. How much did you sell it for?
$48,000.
And how much was left on the loan?
48. It was even.
Well, show me.
It was even. Oh.
I'd like to see that.
Ooh.
So $48,000 was, he paid $18,000.
Hang on 1 second, I got it.
Can I submit this to you?
What is that?
Or this, my bank statement showing the payment?
No, you told me. I
Okay.
accepted it.
Okay.
She doesn't dispute it, and I accept it.
I do have a copy of the title here somewhere.
What I'm looking for, Mr. Smith, just so that you know, what I'm having her look for me, she's going to show me how much was left on the loan and how much she sold the truck for. If she sold the truck for more than was left on the loan, the difference between, you're looking at me, the difference between that belongs to you.
Oh, I see.
Because you paid it, right?
I see. Yes, ma'am.
Got it? That fair? Did she tell you that she sold the truck?
No, ma'am.
He went and bought a truck 2 days later, so he was able to buy a truck.
Okay.
I mean,
would you find those papers for me while you're
I'm
looking for
I'm
those
sorry,
papers for me? Mr.
can't.
Smith, did you buy another truck?
Yes, ma'am.
Good. Did you put a down payment on it?
Yes, ma'am.
And you own it now?
Yes, ma'am.
And you're driving it now?
That's correct.
What would you do with a second truck?
Well, I was forced to buy one because I had
I
no
understand
warning.
I understand you were forced to buy one, sir. But if you had the truck and you weren't going to use 2 trucks, you would sell this truck for whatever amount you sold it for. And if there was any overage, you'd get to.
I offered to purchase the truck from her. In fact, she understood that I was planning to purchase the truck from her.
Don't tell me what she understood. Right now, you don't need a truck, and I'm going to find out whether or not she has to give you any money as a result of what she sold the truck
this
for.
bill of sale does not have the amount on it. I didn't realize that. I'll have to get that from.
Well, this is
where
the
I
time
sold
to
it.
get it.
I'm sorry, I did not realize it didn't have it on there.
Okay. Oh, you sold it to a company?
I did.
Oh, okay. Not to a private party?
No.
Is that the same company that you purchased it from?
No, I purchased it from a different dealership.
Okay. Do you have the exact amount that the loan, the extant loan was?
The original loan was 60.
No.
I'm sorry. The exit loan?
Yeah, the exit.
It was between 48 and 49,000, give or take. Yeah, hang on.
And the truck was, and the truck
I have it.
was purchased for 56, so that amounts for his payments plus interest.
I have it. That's the difference of what they gave me. I originally put the down payment on that truck as well. He did not.
That doesn't matter.
Yeah, that was the difference they gave me in the sale.
Okay, so this is the difference.
Yes.
Between what was on the loan.
Exactly.
Between what was on the loan.
Exactly.
And this. Okay, so the excess, sir, was $2,225. She put in the deposit for the truck when it was originally purchased of $500?
She did not.
Yes.
Who did?
I did, and I have a copy. I have that in this record right here.
Show me.
We added tires, we added all kinds of extra
I don't
stuff
care.
and
I
everything
don't
to it.
care.
and
I don't
I paid for that
I
as
don't
well.
care. I don't care.
Yeah.
This is actually,
Just show me
it's on my phone. Can I show it? Can I?
from 2020.
Yes, what had happened, the amount actually came off of this statement copy.
Let me see.
Can I submit this to you where I made the 2 payments on the truck? When he first started, I made the very second payment and the 4th payment on that truck because he wouldn't make it. I also notified him on June the 20th that he had 30 days to get the truck in his name, and I never heard anything.
You can't notify him within 30 days to get it in his name. That's not the agreement. Let me see.
Yeah. There's this.
Yep. Purchased authorized August 22nd, and this is 2020 for $500. Okay, so the difference of the $500 that came out of your account brings the total excess that she received $1,725. She's coming to pick up her lawnmower within 5 days and her 3 ATVs. At the same time, she's going to give you $1,725, which is the difference between what was owed on the truck and the profit that was made that she didn't pay for. We're finished here. Thank you very much.
This court is adjourned.
I think it was fair.
Well, it was a little less than I thought I was going to get back from it, and there's a lot more to the story that obviously I couldn't get in.
Well, I mean, I had the truth, so.
She understands why that is because there's an outstanding invoice from me for work that I've done that she's refusing to pay for.
I have supported him since 2003.
Construction work, I did a lot of planning and helping her with her current home that she's living in.
It is just one thing after another, and I could never owe him one dime.
I mean, everything was fine between us.
Has trauma bonded me and manipulated me and gaslit me for all these years and kept me around just in case other relationships didn't work out.
Until she found out I was seeing someone else.
No. I had been asking for everything of mine that he kept and held hostage for a long time before that, but he's probably had many more before that. I just didn't know about them.
But I'm happy.
I was thinking he was making me think that we were reconciling while he was using me.
I don't see us talking anymore.
The bank is finally closed, and the bad bargain has just been a nightmare. It's been hundreds of bad bargains.
No more business ventures.
You see, it's always a mistake, unless you're married, to co-sign a loan for anybody. A boyfriend, a somebody.
An ex-husband.
Especially an ex-husband.
Yeah. Because I think what you said was true. There's always one person that gets no benefit and gets slighted and has their name on the line for their credit for future purchases that they want to make, and the guy who gets to drive the truck.
And the guy gets to drive the truck. Of course, he says that the reason she got all hot and bothered is because he has a girlfriend now. I would have felt a little more sympathy towards him had he not gone out 2 weeks later and bought a new truck.
Robin Slagle is suing her customer, Jack McCurcheon, for tuition and administrative fees.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case number 2126, Slagle versus McCurcheon.
Thank you.
You're welcome.
You run a school.
Yes, ma'am. It's a program.
Is it a school or a program?
It's a program.
What's the difference?
The program is not a school where the children come every day. They come twice a week. Parents.
They come twice a week online.
No, we are
in person.
In person, yes.
Okay, so twice a week they are there at a brick and mortar place.
Yes.
And how long have you had this program?
We actually started this program during the lockdown in 2020 spring. So this is at the end of our first semester of our 3rd year.
Okay, and tell me, who runs the program?
I do.
You have an educational background?
I do. I have a master's in education.
Does anybody run the program with you?
I have a staff, but I'm the sole director.
Is this an annual program?
We do operate on a semesterly basis as far as payments, but the classes just roll over from first semester to second semester.
And is there a contract?
Yes.
Okay, and you're going to show me the contract that the defendant signed on behalf of his son?
Yes.
Because that's what this case is about.
Yes.
The only interesting part of the case is your son was enrolled in the program. He was terminated from the program for let's say, misconduct.
That's true.
And it was misconduct that was replicated in violation of the rules at least 3 times.
Kind of.
Not kind of, at least 3 times that you acknowledge.
Okay.
That's not an okay. That's not an okay.
not.
That's either a yes or a no. I mean, I read about 3 instances of cheating. You acknowledge that in your answer.
Well, it's different. It's different.
You mean he cheated differently?
No, he didn't cheat
Yes, well, that's what-
differently. I mean, I can explain.
It was explained in the papers.
Okay.
And you weren't there, so you can't explain. But you acknowledge the fact that he cheated. He was given a warning. You were advised. He cheated again. You were given a warning, and he was allowed to continue. On the 3rd such event, the school terminated him. Is that what I read?
Yes, ma'am.
And that's what you acknowledge in your papers.
Yes. Yes.
Okay, well, that's a yes. And he was within a semester. You would pay the tuition and then try to reverse the payment because you paid on a credit card.
Yes, I paid with credit card, yes.
Okay, and then when you got the bill, you challenged that payment, which you had in fact received, and whatever you told the credit card company as a result of what you told them, the payment was reversed and taken off your credit card.
That is correct.
Right. And so they are here now seeking that tuition payment from a court. That's why we're here, to see whether contractually, because this is a breach of contract action, you were obligated to pay the tuition even though your son was not in the program because he was dismissed for cause, which you acknowledge. Are we clear on where we are?
Yes, ma'am.
Yes, ma'am.
Good. So now I'm going to look at the contract.
I'd like to add that.
Just let me look at the contract first.
Well, if you see contract, they're signed by my party. I want to see it too because I don't see my name. I sign a contract. That's a statement probably, or it's a...
It's a payment agreement.
Yeah, that's not a contract.
Yeah, payment agreement is a contract, sir.
But signed by me?
Well, it says signed, Arena and Jack.
Okay.
Is Arena your wife?
That's correct, yeah.
Okay. So this says, I understand that payments are due even if classes or memberships are dropped, subject to the refund policy. Well, what's the refund policy and where is that in writing?
It is on our website, and they signed it. It was a form that they had to sign.
Well, I'd like to see the form that they signed, because I have to see what the terms are of that.
These are the terms of the refund.
Thank you.
That's a screenshot of our website.
No, the website is unimportant to me. You say you have an agreement signed by them. I'd like to see it.
Well, the agreement that we have signed was the installment agreement, so I'm sorry.
Well, I only have one payment agreement. What I said I want to see is a refund policy. You said you have that they signed. I don't see
They
that.
don't sign the policy. They sign the agreement. The policy is a written policy.
Well, I would like to see the written policy.
That's what we have on our website, and it's clearly...
No.
No? Okay.
No, what you have to do is you have to incorporate something by agreement in this contract. If you say the refund policy as outlined in the website, because other than that, it's meaningless.
Okay.
You know, you're saying we have a refund policy, and we assume that you looked on the website to see what the policy is.
We also do go over it in parent meetings with the parents.
That you can't do because you have a written agreement.
Right.
And anything that's outside of that agreement, unless it's referenced in the agreement, is inadmissible because the intention of it is to somehow change or modify the terms of your written contract. Okay, so in what month did the defendant's son start the program?
In August of 2021.
And it runs in 2 semesters. And when was he terminated?
He was terminated in February of 2022.
You were in a semester program?
Yes.
So am I correct that the first 2 episodes of cheating were in the first semester?
Yes.
When?
The first one was early in November. It happened to be the 3rd week of our 2nd semester. The next one was a couple of weeks later in the same month of November.
Okay, so the semester had started?
Mm-hmm.
Uh-huh.
Semester.
Yes. And on what day in February was he terminated?
He was terminated on February 24th, I believe, yes.
And when you terminated, the defendant, I assume, paid the entire semester's tuition for the second semester.
The second semester, he signed the installment agreement, which is what you have there.
This is a payment agreement.
Right, that's it.
Well,
He agreed
just
to pay in installments.
No, it says, I agree to pay all charges by due dates according to the payment plan. I don't have a signed payment plan from anybody. Do you have one?
I'm sorry, that's what we use for our signed payment plan.
Well, you should use something different. This is not a payment plan. This says he will pay according to a payment plan. I'm looking for the payment plan. You pay by the month, you pay by the semester. How do you pay?
It's a semesterly fee that's broken into 4 payments, so they don't have to pay it all up front.
Okay.
They can choose to, but
And so when was the defendant's last payment?
they paid through the semester,
Through what semester?
second semester,
Okay, so they paid in full.
through the installment. So what happens is they agree to be automatically billed. And so every month, a certain amount comes out.
Just a second. So what you're saying is when they sign up, they give you authority to pull out from their bank
Yes,
whatever the tuition is for that month.
right.
Okay. And according to your records, when was the last payment that you received for the defendant's son prior to terminating him?
Prior to terminating him, we received a payment in February.
And you terminated him on February 24th?
Yes.
How much was that payment?
It was, have it right here. You know what? I don't know.
$350 every
It was
month.
300, that's right. $350.
I know, I got charged the extra month, so I know the number.
Okay. So it was $350 that you paid the beginning of February, and he was there in February.
That is correct.
Okay. In what month did you dispute the charge?
Well,
No, not well. I said, in what month?
May. I only realized in May she's been charging.
Just a second.
He was plagiarized by teachers.
It was plagiarized by teachers.
He was given notice because he lied on a test by teacher, yeah? But it's not exactly what happened.
They're not in the business of expelling children. They're in the business of keeping children in school.
But-
You really have to get this through your head.
Robin Slagle claims her customer, Jack McCurcheon, owes for tuition and administrative fees.
So you paid in February, and your son was there in February.
That is correct.
Did you pay in March?
It was taken out of my account without me knowing, but yes.
Is that $350?
That is correct.
And did you pay in April?
I did pay in April.
Okay. Now, the May payment, is the May payment the payment that you canceled?
No, on the May, I also paid for a May payment. Looking at my statements, I said, why are we paying for the child? He doesn't go to school anymore. And that's where I called them. And then I called my credit card company, explained to what happened. They said, we are going to charge the money back to your account. And that's when I kind of looked through paperwork, and I'm an immigrant this country. I don't read really well. I can speak. And my son, he's a young guy, and he knows exactly what it is, and that's what I brought him. I said, can you see, do we owe these people money? And if you guys allow it, I can have Alex to explain what here shows.
Just see it. He doesn't have to explain anything to me.
Okay.
I'm not new to the country, and I was legally trained, so I don't need your son. I assume you're not legally trained?
I am not.
To interpret something, a piece of paper. So now I will look at the piece of paper that you're relying on, but I want to tell you this, sir. I pay the tuition for a lot of people, a lot, because I have 13 grandchildren in school.
Okay.
I'll take that, Kevin. Thank you, I'm sorry. I know that if one of my kids or grandkids goes to school and gets expelled, and I've paid the tuition because I'm not on a payment plan. Parents send the bill directly. and so I pay the tuition, but I know if one of the kids in November, once I pay the tuition, gets caught cheating on a test or plagiarizing a paper, and he or she is dismissed from the school, they're not going to give me my tuition back, even though he's not in school. I'm not going to get the tuition back for that semester.
That's true.
That's what I'm telling you. I know that. So now I'm going to see what you want me to read that suggests that in this case, even though your son was terminated for cause from the school for cheating.
Dismissal versus termination is different.
No, it's not different at all. It's this exact same thing. Dismissed, terminated, expelled, all the same thing. If you look them up under synonyms for each other in the dictionary, you will find they're all the same. He was excised from the school because he cheated despite multiple warnings. So he was expelled from cause. I just want you to understand that. Did you go to college?
Currently enrolled.
Currently. Stand up. You look like a nice young man. Where do you go to school?
Cal Poly Pomona.
And who pays the tuition?
I do.
Now, what's your first name?
Alex.
Now, Alex, you do know that if you got expelled from college for cheating in the middle of a semester, you wouldn't get your tuition back for that semester. You do know that?
Correct.
Okay, that's all I want to know. Well, that's what we're dealing with
Could
here.
I add something?
Sure.
Well, according to their honesty policy, they made a clear difference between dismissal and expulsion.
I'm going to look at it. Okay?
Okay.
Okay, so what you gave me now acknowledges that you received the refund policy. Thank you very much, because she wasn't able to prove that she gave it to you, but now you gave it to me, so I know you were given the refund policy when you enrolled your son in school.
So we weren't given, but it's something they have it on their website for you to...
Just a second. Well, then you look. You don't have to sign. Then you looked at the website. You gave me this. Do you understand?
After
That's what
this
I mean,
happened,
legal.
I went and tried to understand.
Well,
what
you should have
happened.
done it before.
Well,
You were
I own a
perfectly
construction
capable of
company.
doing it
When
before.
I sign a contract, I sign and I explain everything.
You
and
just
people
told
get
me
copies.
5 minutes ago that you didn't sign any contract. Well, now you acknowledge that you signed the contract. I'm just reading this that you gave me.
A contract has to
Yes,
be
sir.
complete contract. If
Just
there
a
is
second.
something...
For somebody who's, not here, not from this country, and doesn't understand things, you seem to understand things very well.
I know the contract has to be completed.
Oh,
so
well,
if I give
that's
a-
very good. A lot of
Yeah.
people don't know that.
So if I give a contract for a statement, then I say, go in my website to read about our refund policy. That's not part of the contract. That's their rules, no? I didn't sign refund policy.
You don't have to sign a refund policy. You just have to be aware of it.
If I don't know how to get into website or don't...
You gave me the evidence,
But this
sir.
was done after everything done. I
I'm
looked
not
into
sure.
it. Okay?
You were certainly aware of how to do it, either before or after.
When I sign contract with someone, I disclose everything, and they initial, and they get copies. I get copies, and that's a legal bonding contract.
Good. What law school did you go to?
None.
Well, there are two things here, but the final piece here says the consequence for academic dishonesty or plagiarism is a score of 0 on the assignment and possibly dismissal from the class.
Okay.
So your son did that in the first semester at least twice. Repeated dishonesty can result in suspension or expulsion. Now you can stand up because your father says he doesn't understand everything. I think he understands everything just fine. But in case he wants to have you there. Now, when you were discussing this with your father, did you have any conversation with him that suggested to him that, if I went to college and I cheated 3 times or 4 times or plagiarized a paper and I was kicked out of school, I wouldn't get my tuition back? Did you tell him that?
No, we had similar talks, but no, nothing on the school. We talked about, for instance, the signing contract for, let's say, a 1-year lease agreement to live somewhere, but if you breach the contract and they decide to kick you out, it's the same thing as expulsion. You're not required to finish the 1-year contract with them. You don't have to continue paying.
If they decide
What are you kidding?
I am not. If you get evicted from a property, do you have to continue paying the entire year's lease?
Yeah. If you breach a lease, he or she can evict you. And yes, you will be responsible for the remainder of the lease.
Oh, I was unaware of that.
Yes, you will be responsible for the remainder of the lease. You have to understand, and your father has to understand, the reason that he was expelled is his fault. And the reason he was expelled had nothing to do with them. It had to do with your father, because you were put on notice that he was plagiarizing and cheating on tests. If what you're suggesting is the 3 times that your son was caught cheating were the only times he cheated, you're deluding yourself. He got caught 3 times. Because if these were the only 3 times that he cheated, he is the unluckiest person on the planet.
Robin Slagle has accused her customer, Jack McCurshan, of refusing to pay tuition. Jack claims he is not required to pay because his son was dismissed from her school.
You were put on notice, and instead of being more vigilant, the conduct continued. He lives in your house. How old is he?
14.
14. Well,
I want to ask about this plagiarizing thing, which it is, because remember beginning you asked me that he was plagiarized by teachers, which I was not.
He was plagiarized by teachers.
Like he was given notice because he lied on a test by teacher, yeah? But it's not exactly what happened.
Well, then you should have, just a second, then you should have contested it, sir.
Well,
you should have contested it. Did you say?
If they don't want him to be out of the school, they don't want him to be there.
No.
What do you do? I mean, you go
what do you
fight
do?
with them?
What do you do? You pay the tuition for that semester because that's your contractual obligation, and you tell your son you better straighten up. And if I have to take you to a psychiatrist, if I have to take you to a therapist, if I have to find a more rigid school environment, I'm going to do that.
Well, he really didn't cheat.
You really have to get this through your head.
When he says cheating, last time he was expelled from the school. Do we have a...
No, don't look at her.
That day he had an excellent score on his math, and his last test was his history, and he forgot to learn the history, and he did have a paper with him, but he did not cheat it. Actually, there is no proof he cheated that day.
All right. They're not in the business of expelling children. They're in the business of keeping children in school. How many other students were expelled from the school the semester that this defendant's son was expelled?
0.
Yeah.
Wow.
They're in business of keeping children in school. How many
my
children?
son was that bad for her to expel her.
She said they didn't expel any other children. I'm going to ask her, how many children were enrolled in the program at the same time the defendant's son was enrolled in the program?
Approximately 70, 75.
Okay, and of the 70 to 75 students, the only student expelled was the defendant's son.
Yes, ma'am.
That should tell you something, sir. Stop making excuses. Okay. I didn't tell you, he didn't look at the paper, he had it underneath him, but he didn't look at it. Well, plagiarizing. So he copied from somebody on a paper that was supposed to be original work, did it once, he did it twice. Do you understand your son has a problem?
Well, we all have problems.
No, I never had a problem being expelled from school, sir, for cheating. I never had a problem being expelled from school for cheating.
I have lied.
I have 5 children and 13 grandchildren. All have completed college, some professional school. None of them have ever been expelled for cheating. That's a lot of people.
Do you feel it's fair to expel a child from a school because of
cheating? Absolutely. Not that I usually let people ask me questions, but the answer is absolutely. Because if 70 children are working hard to get good grades and studying and creating original works when they're supposed to create original works, and your son who's getting a 99 on a math test when he's been getting low scores on tests, all of a sudden becomes a shining star one day, and it's a pattern, and then they find another cheat sheet under his bottom. That's something that suggests to the other 70 students that are trying to do the right thing, that it's okay to cheat. And so if you want to cheat on this test to get a 99, it's okay. You can't run a school where you permit kids to mingle with kids who are trying with kids who are cheating. So do I think it's fair? Absolutely. Okay, how much money was reversed by this bank?
$1,050 plus $45, a $15 fee per transaction.
$1,095. Okay, judgment for the plaintiff in the amount of $1,095. Sir, your problem is not with the plaintiff. Your problem's with your son.
He's like all of us. He made a mistake. And
no, he didn't make one mistake. I'm going to tell you something. Honestly, I used to say when I was practicing in a different court that if criminals got caught the first time or every time that they committed a crime, they'd stop committing crimes. The problem is they commit a crime and they don't get caught. And then they commit another crime and they don't get caught. Then they commit third crime and they get caught and they're brought to court. And their lawyer argues this is their first arrest. Not their first crime, because they can't argue that, but it's a first arrest. So if what you're suggesting is the 3 times that your son was caught cheating were the only times he cheated, you're deluding yourself. He got caught 3 times. Because if these were the only 3 times that he cheated, he is the unluckiest person on the planet. Okay, we're done here. 1095, judgment for the plaintiff.
Thank you, Your Honor.
This court is adjourned.
I felt the difference was between different wording, what it means as far as being expelled versus being like sent home.
I'm extremely pleased. This was totally a matter of honesty and integrity. And obviously it stems from the father down to the son.
But he explained that's the same word. And again, that's why you come to court, and she did what she had to do.
We have kids that try to cross the line, come close to that line. But as I mentioned, our instructors are pretty savvy and they're on it, and we can tell pretty much so.
I am happy finally done. It's been a burden, it's been a stress, and hopefully it's done.
Cheaters never win.
So I think it's really important for the plaintiffs, as the runners of a homeschooling system or a schooling system, to have a better contract for the parents that are signing, especially with a payment plan option. There should be exhibits attached to the signature page, not just referencing, oh, we're agreeing that we read the policy from the website. It's just as easy for you to reprint it, attach it, and require a signature, an initial on the bottom, so that you don't have parents like these that say, I never went to the website, I never saw it.
I agree with you.
If you have problems like this, there's no denying the fact that you initialed each page and each policy.
I think that it's a learning experience because they just started the program in 2020. And this is probably the first experience that they've had because he's the first, never expelled anybody else. But they'll clean up the contract.
Paul is suing his neighbor, Stacy Benedum, for breach of contract and attorney fees.
Court come to order. All rise.
Have a seat, please.
Case 2128, Hall versus Benedum.
Thank you.
You're welcome.
Mr. Hall, you and the defendant are neighbors.
Yes, ma'am.
And your houses are right next to each other.
Hers is on the corner, mine is
right next to her.
Yes.
Got it. What your complaint is that I see where those two, the truck and the vehicle behind it.
The trailer, yes, ma'am.
The trailer. The property to the left of that is your house.
Yes, ma'am.
And the property to the right of that is the defendant's house.
Yes, ma'am.
And it is your claim that the defendant, in writing, agreed to sell you that little piece of property that looks like it's been carved out of her property.
Yes, ma'am.
Because you had a narrow driveway, you wanted to park these two vehicles.
Yes, ma'am.
Based upon that agreement, you went ahead and did some work on that piece of property.
Yes, ma'am.
You put down gravel, you planted flowers, all to make it look as if that piece of property was part of your house.
Not so much to make it look like it's part of my house so I can get in it, because the agreement was that there was 3 pine trees there prior to her telling me that I could buy the property.
No. The 3 trees that are there had nothing to do with this except that they were taken down. And were they taken down and the removal of the trees was paid for by you or by her?
By both of us.
By both. Okay. So you asked to have the trees removed, and you both paid to have the trees removed.
Okay.
Not only did you cut the trees down, but you took that property and made it look like yours. You say that there was an agreement in writing for her to sell you that piece of property. So I'd like to see that agreement.
Yes, ma'am.
There's no agreement in writing.
Don't say anything.
The very top line.
Just a second. This is not a contract, sir, to sell land.
I have a lot more.
Shh. Not a contract to sell land. I see what she says to you. I am agreeing to sell you the property you are currently parked on for $1,000 plus costs. Let's get this in motion ASAP. And then she doesn't hear from you, and that's the 18th of May. And then she writes you again a little bit later, and she says her offer will expire at the end of today's business day, 5/19. And on 5/19, at 10 o'clock at night, you write to her, "Hey, Stacy, I've started working on things this morning. I have already been to the city of Akron, and once they are done and I get a surveyor and so on, I will keep you updated if that's okay. Last, everything is time sensitive, and I'm working as fast as I can to get the approvals. Just now seeing your texts."
Right.
Okay,
The
so
next
that's
day.
what you're relying on as a contract to purchase property.
Well, the fact that she said that she would sell it to me, and I started all the motion like she said to do. I started all the motions, got the surveyor done, got the deeds done, I got everything done.
All right, that was 5/19/2021. So show me what you did based on this and what you spent based on your belief that she had agreed to sell you the property and you had an agreement for sale, which is like a contract for sale of property. Most people know that when you sell a piece of property, you get a survey, you put it in the contract, you have a contract when the property is going to be transferred. That property would have to be surveyed because clearly you're carving a piece of property out of her property. I want to see what you did and what you spent, because if you spent money based on this, I may consider that as part of your lawsuit, because then it turned out she didn't want to sell you the property. By the way, I wouldn't sell them the property either. It makes your property look ridiculous.
It does. We never agreed to sell the property. Okay.
Did you write, "I am agreeing to sell you the property you are currently parked on for $1,000 plus costs"?
Yes, I had never agreed to sell the property until I told him he was no longer allowed to park there. It was never discussed.
What is this?
Depending on the stipulation that my mortgage company requires, which is an appraisal, they had to approve the selling of the property.
All I'm interested in is this one line. The other ifs fall after that. It says, "I'm agreeing to sell you the property you are currently parked on for $1,000 plus costs."
Yes.
Okay, so you did that.
Yes.
I want to see the things that you started to do right after May 19th. You said, "I've already started working on things this morning." This is May 19th. "I've already been to the city of Akron."
Yes. This is a receipt showing the $800 from the surveyor.
Okay, may I see that, please?
There's that one. This is a receipt from the attorney where I had the deed paperwork done.
I'm looking for a date on this, sir. I'm looking for dates on these
You can
things.
look at this one too.
Okay, June 15th. What is this?
That's actually when I paid to have the 3 deeds made up. That's the $450 that I had to pay to the attorney for him to make the 3 deeds up. And everything Stacey had to do was sign them.
And that was June 15th. That was not quite a month later.
Right. I started the next day.
Okay. And this is so far what you spent in reliance on her statement that "I'll sell you the property for $1,000.
This is a breakdown that I have, that I wrote down, that you can show her that, of everything, the timeline and...
Now, I don't need a breakdown of the timeline, sir. I need the bills for this, not what you wrote.
Okay.
I need the bills for 6 tons of gravel. That was in July.
Here's one receipt right here. There you go.
Did he ever give you $1,000?
He never paid me.
I'm a common sense person and a property owner. It was overreaching to think that you could buy a piece of that land for $1,000. Overreaching.
Julian Hall claims his neighbor, Stacy Benedum, owes for building costs and attorney fees. Stacy is countersuing, claiming Julian was illegally parking on her property.
Okay, so far all I have that you paid was $450 for the deeds, $800 for the survey, and gravel to be delivered.
I got the gravel in there. I also have the concrete that I had laid, flowers and stuff that I put in.
Did he pay part of having the tree stumps removed?
We split the cost and the labor of removing the debris of the trees.
No, ma'am,
What?
that's not true.
Who wanted the trees removed?
I never had a problem with the trees. I like the trees.
Don't speak.
He wanted the trees cut down so he could have more space. He was already parking underneath the trees with a smaller trailer, just not his truck. He wanted more space, so he came to me and said, "Hey, what if I split the cost of the cutting of the trees?" I said, "That's fine, I'll split the cost. That's fine with me." And then I agreed to let him continue to park there as long as there was no tire marks. That's what it was. And then he built this thing.
Well, he formalized parking there. Okay. At what point did Miss Benedum tell you that she was not going to sell you the property?
This actually started on 4/3 of 18.
I'm not interested. I'm interested in the beginning of these texts, where you clearly had discussions. Trees were removed. I don't quite understand why she allowed you to remove the trees, and I don't understand the whole transaction.
Because it wasn't my choice.
Just a second, it was your choice. You wanted to park there. That's what you wanted.
But the trees was dying.
I don't care if they were dying. I don't care if they were shriveled up. I don't care. You carved out a piece of property. Now, if you carved out a piece of property that belongs to her and you didn't have an appropriate agreement in writing, which it has to be, then I believe, based upon her statement that you acted on, you're entitled to whatever you spent to renovate that property. Do you understand? You're not entitled to the property.
No, I understand.
You're not entitled to the property. You're entitled to what you spent to renovate the property. So now I want you to tell me, on what date did she tell you that she was not going to sell you the property?
That was 7/20 of 21. After I got everything done and called her, it's asked her, could she meet me at the bank? She said, no, I'm not selling to you for $1,000. But it goes deeper than that. That's what I'm trying to explain to you. It goes deeper than that, because when it came to the trees, I didn't approach her with the trees. She came to me and said, since the tree was dying, I said, well, I'll go in half with you. At that point, I said, when can I use the property? She said, you can use it as long as you need it. So that's when I started investing all this money into the property.
So what? I don't care. She said to you, you can use it as long as you want.
Yes, ma'am.
Okay.
I said nothing permanent.
She said, as long as I need it. That's why I invested the gravel.
What I'm telling you, sir, is the purchase and sale of property has to be with a certain formality. If you dealt with an attorney, the attorney would tell you that it had to be in a formality, signed by her, signed by you, the contract that provided for sale, when it took place, what the survey was, whether her bank would agree to let her sell off a piece of the property because you have a mortgage, all of those things. That's why agreements to sell real property, which is land, have to be in accordance with a certain set of rules. This doesn't make it. However, if you relied on her statement in order to improve the property, to make it comfortable for you based upon her text message, I believe that you are entitled, based upon the text message, to what you spent to improve it. But you have to understand, she's not going to let you park there anymore.
And I'm okay with that.
Just a second. Are you still parking there?
No, ma'am.
Since when?
I would say September of 2022.
So you were parked there in July of 21, August of 21, September of 21, October of 21, November of 21, December of 21, January of 22, all the way up to September. You were parking there.
This is because we had...
Don't give me a because.
No,
that's either a yes or a no.
I was parked there, but we also had a civil case, too.
Which he dismissed 2 days before.
We had a civil case. She called the police.
He called the police on me twice.
The question was, when did she tell you she wasn't going to sell you the property?
September, when she agreed not to meet me at the bank. That's when she told me she wasn't going to sell.
September of 2022?
Yes, ma'am.
I never knew we were meeting at a bank.
Just a second. So
I can do better
in
than that.
September of 2022, she advised you.
No, I'm sorry, it was August of 2021.
Well, show me in August of 2021 that you told him you weren't selling him the property.
Here's.
Okay, I'll take both, Kevin. Thank you.
And this was after she agreed.
Shh. Okay. I'm just looking for the date on this.
Yeah, there's not a date on there, I'm sorry, but that was after May 18th of 2021. That was maybe July or August of 2021 when I told him, since he didn't meet all the requirements, that I no longer want to sell it.
What requirements?
He never met the requirements of paying me the money or getting the land appraised. The only thing he didn't do that my mortgage required is the appraisal.
Ma'am, that wasn't true, because I did everything that the city of Akron told me to do, who deal with this on a regular.
Did you get an appraisal?
I got the land surveyed. She didn't tell me about nothing about appraisal until after I got everything done.
That's why you have a contract in writing for the sale of property, sir. I don't think you did anything intentionally wrong, but there was an appraisal that was necessary. Clearly, if she has a mortgage and a bank is giving her a certain amount of money on a parcel of property, and she wants to sell off a piece of that property, the bank is going to want to know how much the value of the property has diminished by her selling it to you. So you have to have an appraisal. Do you understand?
I understand that.
Okay, and you didn't have an appraisal. I'm not going to tell it to you again. And all I want to know is, when she first told you that you didn't have a deal. So once she told you that you didn't have a deal, whatever else you invested in this property was on you.
No, and I didn't invest anything else other than getting an attorney and paying everything I needed to pay him.
Once she told you that she wasn't selling the property to you, what'd you need an attorney for? You're not the aggrieved party here. You got to park for free because she was a good soul. I would have had your trailer and your truck towed to an impound on day 2.
Julian Hall has accused his neighbor, Stacy Benedum, of breaking their agreement. Stacy claims there was never an agreement and is countersuing for parking fees.
Once she told you that she wasn't selling the property to you, what'd you need an attorney for?
Because I had already had an investment after she said she was going to sell it to me. Once the attorney got involved, he told me to dismiss the case. Then after that, like 3 days later, I moved off the property.
Just a minute. So who brought a civil case?
I did.
When?
Last year of 21.
And what happened with that case?
It was dismissed.
What did you bring a case against her for?
For breach of contract.
It was dismissed because there was no contract.
Your Honor, can I say something?
What?
He made all these improvements in 2018 before we ever discussed selling the property.
You mean he put the gravel in?
Yeah.
Well, how could he put the gravel in over trees?
The trees were cut down in 2018.
Is that right, sir? Hey,
that's correct.
The trees
yes,
that were cut down in 2018, well before this.
Yes.
So you did use it. You used it for how many years? You used it 18, 19, 20, and 21. You used it. You used it. You had value from it. You had value from somebody else's property. You used her property for you to park on. You can't.
I wouldn't have done none of this if she would have told me no. Every move that I made, I asked her first. I got it in text message. I asked her, can I do this? Can I do this? She said, yeah, go ahead and do it. If she would have said no, I wouldn't have done none of it. I wouldn't have put a dime into the property.
I'm not going back to 2018, sir. If you made these improvements in the property in 2018 or 2019, before there was any hint of a writing that she was going to sell you property.
She had a verbal that I can park there as long as I wanted to.
Okay, your case is dismissed, Mr. Hall. You don't have a case. You did park there until she told you not to park there anymore. And you had the benefit of parking there for at least 3 years.
I got money invested that she told me
you had the benefit of parking your things there for at least 3 years. Are they gone now?
His truck and trailer are, but the gravel's still there, and we have to clean up, get rid of that stuff.
It was a huge mistake, so you're going to have to take care of that yourself.
Okay.
And I would take care of that because that looks ridiculous.
I will.
That looks ridiculous. You have a counterclaim.
Yes.
For parking. Forget it.
But listen, I told him he couldn't park there back in May of 2021. He continued to park there till...
So you should have been more vigilant.
My attorney didn't notify him till May of this year, of 2022, that if he continues to park there, we'll charge him $75 a day. And he continued to park there until the case was dismissed in August of 2022. So I'm only suing him for May of 2022 to August of 22.
And did he move it?
He did.
Okay. You still living there?
Yes.
Do you talk to him?
No.
Had you talked to him previously?
Yeah.
We had a good relationship.
I'm a common sense person and a property owner. It was overreaching to think that you could buy a piece of that land for $1,000. Overreaching. And if she had it appraised, and if it's something that you want, and she had, I guarantee you that that little piece of property would be appraised at a far higher cost than $1,000. Guaranteed. And I guarantee you that her bank would say, you can't let him buy that piece of property for $1,000. How much of a mortgage are you carrying?
$76,000.
Not going to let her sell off that piece of property. You had the benefit of that piece of property for several years. I have to tell you that I really think that it's much nicer to look at plain grass than it is to look at a trailer and a truck from her backyard.
Your Honor, I wouldn't have done none of it if you would have said do it.
Do you know what your attorney said to you? I can't help you. You don't have a contract. And Mr. Hall, that's what I'm telling you. I can't help you. You don't have a contract. And from what I know now, this all started in 2018 before there was any discussion of buying the property that you can prove to me. Because the thing that you gave me was in 2021. I have to tell you, you never had a problem because she was a good neighbor. If she let you park on her property, so if you think you're the one who's been aggrieved here, the truth of the matter is I don't think that you're the one who was aggrieved here. She let you park on her property. I have to tell you, I wouldn't have let that happen. I had a neighbor who had an easement. And I said, all I want from you when I bought the house was I want you to say that you will never try to claim this property by adverse possession and that you understand that it's my property. And then you can use it because it was a place that looked like it was part of his driveway. And he said, I'm not signing that. I said, if you don't sign it, I'm going to put a fence right in the middle of your front lawn, which is where my property line is. I don't hear from him. I said, you have 24 hours to sign the paper or I'm putting a fence right in the middle of your front lawn, because that's my property and you have an easement. And he didn't sign it. He would have lived with the fence until today, because it's still there. Now his children are living with the fence because he's gone. You're not the aggrieved party here. You got to park for free for 4 years. For free. Because she was a good soul. She's not a bad guy. She was a good soul. I would have had your trailer and your truck towed to an impound on day 2. She let you park there for 4 years.
I wouldn't have been there.
Goodbye, we're done. Thank you.
This court is adjourned.
She knew what type of work I did, so she said as long as I needed it.
It was just a tough lesson of being nice to the wrong person.
It did look like it was part of my yard, so I get that part.
I hope we can be cordial and just move on with our life.
It is what it is.
This is a great example of the statute of frauds and why it exists. So all writings for the sale of land, real estate, have to be in writing and signed by both parties. I'm sure it was created for situations just like these. There's a lot of moving parts. There's mortgages, there's banks involved a lot of the times.
There are easements, there are water rights,
Exactly.
there are all kinds of things.
Legally, they're some of the most complex documents that get drawn up. So it can't be a text message for $1,000 to sell off a piece of land without all the boxes being ticked.
Right. After May of 2021, when she wrote that piece.
For his detrimental reliance on the statement.
For his reliance on that statement to his own detriment by putting in gravel and other stuff.
But then it came out, it was way
It was put
before.
down in 18 before she ever said anything about selling
Took it upon himself.
Yeah, that would be on him.
Yeah.
And I don't feel badly for him because he got to park on property.